to the community. Okay, so we have a few questions here from the community tab in the YouTube channel. So here's a question. I need help. I'm incontinent. I can't walk fast. I can't run, and I'm 58 years old. No one helped me in 2 hit and runs, November of 2019 and June 15th of 2024. And he gives the intersections where they happened. I'm 58 and homeless, and I don't have auto insurance. I was hospitalized from the first hit and run. I'm disabled, and I got hit again. Yeah, I know. I'm really sorry to hear that. I mean, I think something like that, we would need to maybe speak with you to see exactly what's happening with the case, what the liability is, so feel free to just text me for something like that. It's 347-566-9595, and then we could schedule a call, and I'm happy to dive into, because you have two different cases, one in 2019, one in 2024. So I'd have to see what happened in each case, what the insurance is, all these kinds of questions, where they happen in terms of the city, if it's the same for both or different, and then we could do a deeper dive, and I could give you a personal consultation to answer your specific questions. That's always better to do, personally. Okay. And I see we have some questions now right here live as well. Let me put in live chat, so I see all the chats. And Lakeisha says, hey, good afternoon. Yes, good afternoon. Rain and Dream says, good afternoon. I texted just a few minutes ago. Okay, great. So I'll take a look at that. I don't know if you mean you texted me, to my number, the 347-566, or somewhere else. Maybe he means to the channel. But either way, it's fine. You could also just text me to 347-566-9595, and I'll get back to you. We could schedule a call. I did 2 or 3 calls today, so I'm trying to get back in. And it was a little busy at the beginning of the week, so I apologize if I didn't get back to you, but now I'm getting back in the swing of things. Okay, and Lasana says, how long does the back and forth negotiation normally take until you come to an agreement? Yeah, so I mean, that's really it's hard to say, because it's not everybody negotiates in a different way, right? There's not a standard negotiation that everybody follows. So it just depends, right? Some people call up and they just say, and then the carrier will say, the insurance carrier, right? They usually have the money, the adjuster. So some adjusters may say, you know what, don't call me at all. I don't want to deal with plaintiff lawyers. Call the defense attorney. So then you have to call the defense attorney. And then you make a demand. You say, hey, I want $1 million. And the defense attorney says, oh, I can never get that. Come down, right? They want to drag you down. And they say, if you demand something more reasonable, if you demand maybe, 100,000, then I can go to the carrier and I could recommend it and I'll get you some money. See, they make it seem like, oh, you have to come down really low, then I'm going to go and I'm going to do my best. I'm going to work so hard. I'm going to get you some money. It's like they're giving you a gift or something. But in reality, the defendant was negligent. The defendant did something that was not using reasonable care, and their negligence caused a serious life-changing forever injury. So you're entitled to this compensation out of fairness, right? You're entitled to it because they did that to you. It's not like you asked for this. Nobody wants this, right? So I don't like to negotiate that way. The way I like to negotiate is just to say, look, here's all the evidence, all the medical records, bills, whatever you need. Here's the human story, photographs, depositions. We believe this is worth, let's say, $1 million. Pay it in 30 days, right? You have 30 days. If you need anything else, I'll give it to you. If you feel like you don't have information, like whether it's medical records or anything that you need, photographs, you want to speak to witnesses, whatever you need, I'll give it to you. If you're in good faith saying that you want to, try to come to a settlement, but you need more than 30 days, I'll give you 60 days, whatever you need. I'm just very, very accommodating towards them. But I say basically, pay me the $1 million. You have until, let's say, April, 19th at 5 p.m., 30 days from today. And if you don't, that's fine, but it's not going to be $1 million anymore. Then it'll be $3 million. And then it might continue to go on up as I prepare for trial. By the time I get to trial, it'll probably be $5 million, and I just tell them, but you have to also follow through on that, right? So it just depends on how you negotiate, right? So, but to answer your question, I mean, sometimes it could be done in one phone call. If it's a small case, you can just call and say, hey, we're looking at 100 for this. And they say, okay, we'll offer you like 75. So now you just have to bridge the gap. Maybe you sell it for 87.5. It could be, you could be really far apart where you call and you say, I want $1 million. And they say, $1 million? Are you crazy? We have this case evaluated at 10,000. Well, now you could have 100 phone calls. Nothing's going to change that. You have to litigate. And then later on, maybe one of you will go up or the other one will come down. So it just depends on how you negotiate, but there's no magic number to the number of phone calls that you need to settle a case. Sometimes, like I had a case recently, that I'm still working on, where I've had many phone calls. I sent letters, and for whatever reason, the defendants just never responded. Maybe they're too busy. I don't know. So we finally went to court, and in court, there were some fruitful discussions with the judge, and then the judge now scheduled a mediation. So hopefully that leads to something. So, sometimes you get a judge involved. Like every case is different. There's not like a one size fits all for that. Okay, and then Mighty K says, why and when would an attorney need to hire an appellate lawyer? Is it before trial or after an appeal? Right, so an appellate lawyer would probably be, depends, right? Also, like usually for the appeal, if you have an appeal, you get an appellate lawyer to write the brief or to respond to the other side's brief. But sometimes you might want an appellate lawyer to sit in on a trial if it's a big case and just watch the trial and see if everything was done properly. And then the appellate lawyer will tell you, you know what, the judge made a mistake on this ruling, and therefore if I appeal, I could win, and then you get a new trial. If you lose, for example, and the defendants do that as well. Because if there's a big verdict, like $50 million, $100 million verdict, they don't want to pay that, so they have their appellate counsel there. Oh, wait a minute, but that was a mistake. I could appeal on this ground because the appellate lawyers know, and then we can get it reversed. So sometimes they sit in, but that's usually for the bigger cases. And then Willie says, hi, Arkady, good evening. Hi, great to see you. Sadeh says, good afternoon. Good afternoon, absolutely. And Rain and Dream says, yes, he texted my number. Okay, yeah, I didn't see a text today. Oh, okay, maybe, no, I do see a text. Okay, yeah, I'll get back to you. Absolutely, I'll be happy to help. And then Mighty K says, would the appellant attorney get paid if the case settles before trial or while the trial is in motion or after the appeal? Well, I mean, usually the appeals lawyer, the way it works is the lawyer that hires them just has to pay them. So usually it's like more like, hourly or flat fee. They might say an appeal costs like $5,000, but they just pay them. And then I don't know how that works out, whether they just pay them or whether they have it in the retainer that if there's an appeal, they have to charge like a little bit of a higher percentage. Like instead of 33, they might charge like 40, and that way get their money back for paying the $5,000 or $10,000 or whatever it was for the appellate lawyer. So that's usually how they do it. And then Sarah says, I texted you earlier this week or late last week. I'm in Wisconsin, I believe, and I slipped and fell on ice and injured my knee. The property also had poor lighting conditions without pictures of the incident. And how likely is it to prove fault? So you slipped and fell on ice. Yeah, I mean, that could be a case. I mean, they shouldn't have ice, as long as the ice should not have been there wherever it was. Like if it's a walkway where people are walking, as long as it's not a storm in progress, like it's not snowing or raining sleet now, well then, if the storm ended, let's say 2 days ago, well, they had time, 2 days to clean the ice. There's no reason for the ice to be there. It's kind of like common sense, just those kind of arguments, just whatever is reasonable care. And if they didn't fix it, then they didn't use reasonable care, then they were negligent. So, the fact they didn't have lighting, you would expect to have lighting in walkways. So, yeah, I'll take a look at that also. I'll get back to you, or just text me again if I didn't respond. And I'm happy to, maybe I'll do a few more consultations. I did like 3 or 4 today. I'll do 2 or 3 tomorrow and Friday as well. So just text me again. I'm happy to chat with you. And then T. Kizzy says, the lawyer said I have permanent back injuries. Early in my lawsuit, I had 2 herniated discs in the back and hand tear. Could I still get the $100,000 even though my injuries healed? And I had 2 injections and physical therapy. Yeah, I mean, it's definitely possible if you have permanent back injuries So it just depends on what the injuries were, like if they were herniated discs, you know, if you were recommended to do like some kind of surgery for them, even though you didn't do the surgery and you feel like now it's getting better, they're still permanent injuries. And you had a tear in your hand, so a tear usually is not something that's going to go away. So yeah, if the doctor recommended surgery, like arthroscopic surgery for the tear in your hand, even though you decided, let's say, not to do it, you could argue, hey, but I'm going to need to do it later, like in 5 years. So therefore, it's worth, you know, 100,000 is not really that much. So it definitely could be worth that. And then RG Society says, hey, Arkady, the best and most, I lost the text. The best and most honest lawyer in the U.S. Super clear in every topic. Oh, thank you so much. That's really great to hear. Yeah, no, we had some good news today. Like one of the cases actually that I worked on, it was actually a gentleman, I believe in the state of Georgia. I referred him to a lawyer that I know. This is the second actually win, because I had another case in Georgia that I referred to a trucking lawyer, a different lawyer, but also excellent lawyer. And I think that first case settled for like over $2 million. And now today, this case also settled for $1 million. And he was really happy. We talked today, and I was really happy for him because, you know, he had this lawyer before, and, you know, the lawyer was telling him this is worth like, I forgot what it was, but it was like less than 100,000. And he was like stuck, and he was like, oh my God, what am I going to do? They're just telling me this is not worth 100,000. And then even after, you know, I told him, I gave him a consultation, I recommended somebody for him. And then he switched over. He got like a really good trial lawyer, one of the best in the country. But even they were being told, oh, the insurance company will never pay more than 100,000. But they just said, okay, fine. And they did like, you know, my method, basically say, look, but they prepped it for trial. The case had some issues, you know. We might actually have him on the channel later. He said he's willing to come on, so maybe we'll do a video together and ask him some questions. He's a really nice guy. But the idea was that, look, he would have been stuck, and even, you know, these guys couldn't even get more than 100, but then because they prepared it for trial and they were ready, they got everything done, subpoenas, ready for trial, not afraid, ready to pick the jury, do like opening statements. The insurance company said, oh, these guys are the real deal, so they paid $1 million. So that, like, I was really happy for him that he was able to get that kind of result, because, you know, if it wasn't for this change and this help, this consultation, and this, you know, getting this other lawyer, this trial lawyer, that would not have happened. So I just I want to help, you know, as many people as I can, because I see that, and, you know, unfortunately, I can't help everybody, right? Because sometimes people come to me very late, like I'm trying to help someone now, but I don't know, because it's not up to me, it's up to the lawyer, because wherever you are, right, whether you're in Pennsylvania or Georgia, this person was in Georgia, Florida, California, Oregon, right? Depending on what the laws are there and whether the referral, the new person wants to take the case. A lot of people don't want to take cases that were handled by other lawyers, so that's the issue. But in that case, I think it was fairly early. So, and it was fairly quick too. I think it just happened in 2024, I believe, right? In mid 2024, I think he switched over, and today he called me, said he already signed the release. It's all settled, so that's good news. Okay, let me go back to the questions. Hassan says herniated disc L4, L5, 2S1 in Scottsdale, 2023, epidural injections, nerve ablation in August of 24. My attorney isn't keeping me in the picture or has answers for my medical expenses since August. Well, you know, that's not good. I mean, the injuries seem pretty serious, herniated discs, and I don't know if you mean Scottsdale, like it happened in Scottsdale, or it's because Scottsdale is also an insurance company, so that's why, or you mean Scottsdale Insurance. Probably it happened in Scottsdale. But yeah, Arizona, I can help you with that. I know some good lawyers in Arizona. If you need a second opinion, just text me, 347-566-9595. Yeah, absolutely. And Zafraz says, hey, sir, how are you? I had a radio frequency ablation injection in the back today. I already did my deposition, and I have IMEs next week, also in May, and case will also be on the trial calendar next week. Would the defense depose again? You mean, do you have to take a deposition of the defendant again? No, if you already did that, you don't have to do that. It's only done once. It's just the reason your lawyer asks questions of the defendant, if it's a car crash, is just to establish that they were negligent. What happened? They didn't see what they should have seen. They hit you. If it's a car crash, right? Just like simple stuff. So it's more about liability. And if they question you, it's about your injuries. But whether or not, oh, I see what you're saying. If they're going to ask you to question you again because of these injections, and I don't think so. It really depends on where you are, what the judge will, if they demand that, and what the judge will rule. RFA is just a procedure for an injury that you already have. So if you already pled the injury, like the herniated disc, the fact that you had an ablation, it's just like to burn the nerve so you don't feel the pain. It's not really a new injury. So there's no reason for them to depose you again. So I would probably say no. But, you have to ask your lawyer, and it's up to the judge. Sometimes the judge will allow it. But even if they do those post-surgery depositions, they're really short. What are they going to ask you? Did you have a surgery? Yes. Why did you have it? Because the doctor told me to, because I'm in pain. Thank you. Okay, no further questions. Like, what are they going to ask you? Those things take like 20 minutes. Okay, and then Sade Love says, I have multiple herniated discs in the back and neck, arthroscopic ankle, back, and 2 shoulder surgeries. Now I have a cervical and lumbar discectomy. How much do you think my premises liability may be worth? Yeah, I mean, it's hard for me to say, just like that from a comment. I know, like in New York, for example, if you have, well, first of all, with premises liability, it all depends on liability, right? If you have a good premises liability case, like, for example, I'm sitting here, the ceiling falls on my head, that's a good case. Hey, if I complain to the landlord, hey, there's a crack, they don't fix it for weeks and weeks, that's a strong case. If I'm walking in an apartment building and there's like a puddle leaking from the ceiling, I don't see it, I slip, I fall, also could be a strong case. But some premises cases could be much harder, right? They might be not the strongest. They might be cases where the person who fell could be partially to blame, right? So then that would affect, obviously, the value. But in terms of the injuries, herniated discs, arthroscopic ankle, I mean, I've had cases with ankle surgery that I've settled for like, $200,000, $300,000, herniated discs on 2 shoulder surgeries, right? So you're saying ankle and 2 shoulders. So yeah, I mean, that could even be approaching $1 million because you have all those 3 arthroscopic surgeries and herniated discs. So, and the cervical and lumbar discectomy. So that could be over $1 million. I mean, if the liability is good in New York, that could easily be like, I settled just one like lumbar discectomy, percutaneous discectomy, which is a minimally invasive one, right? With a striker decompressor type needle. It's an in-office minimally invasive procedure. You can go home after. I settled one of those for like $550, just that. So you have that plus the cervical. So that's, if you say $550 double, that's already $1 million plus 3 arthroscopics. That could easily be like 1.5 even. It depends on like, who's handling it, how it's being prepared. I don't want to give you like false, because like if you don't have a trial lawyer, they might think it's worth 100,000, right? So I don't know who's handling it, where it is, all these different things would affect it. But like if it's prepped the right way with good liability, that could be worth more than $1 million for sure. And then Willie says, I spoke with my lawyer yesterday. They said they might skip the demand letter and go straight to the litigation phase. Is this good or bad? My stipulation is almost up, 2 years coming June 29th. I mean, I think any lawyer that is a real lawyer just like files the lawsuit as soon as possible. There's no real reason to do a demand letter before you file a lawsuit, unless like you think that they're going to be fair. They're not usually fair in the pre-litigation stage because it's just a claim. Like you're claiming you're injured, right? And it's a claim. Like anybody can file a claim. You don't even need to be a lawyer. You could do it yourself. You just send them a letter. I have a claim. They don't care. Like, okay, you have a claim. Great, claim. Let's get rid of it. Like I spoke to someone today. They told me the adjuster called them up and they said, you have a claim. I'll give you $700 or something. Like that's what they want to, how they want to settle claims. So like, why do you want to, even waste your time? Like just file a lawsuit. They could always pay you money. Like, it's just like, what's the difference? Like basically by being in the claim stage and not even being in the litigation stage, you're basically just like sitting there waiting. Nothing's happening. Like the case is just laying there, like a piece of paper laying there, on the insurance company's office. And I mean, unless they're like, know your lawyer and they're super scared of your lawyer, they're not going to just pay you millions of dollars. That's very rare, you know. So in that case, the lawyer should file a lawsuit because he's taking the first step to starting the case, right? They have to appear in the case. You have to go see the judge. There has to be a scheduling order. You do depositions. Then you have to do paper discovery. Then once all that is done, you certify it as trial ready. You see, at any point in this process, they could pay you money. So like the same money they were going to pay you had you not filed a lawsuit when you were in the claim stage in the beginning, they could just pay you that money in the lawsuit stage. So I don't really see why anybody would wait. Like, it's not a big deal to file a lawsuit. Like, if you have a law firm and you go to court and you know how to do it, all the case management software is out there, whether it's, Filevine, or they have Litify, Smart Advocate, whatever you use, or even if you just use like, a typewriter or, Microsoft Word, it takes like 15 minutes. You press the button, lawsuit comes out. It's not a big deal. So you file the lawsuit, and now they have a litigation adjuster on it. They set the reserves. They have a law firm assigned. They take it more seriously because, in the claim stage, they give it to like an adjuster. And I did a bunch of videos based on that book, Deny, Delay, Deny, Defend, and they were saying like these adjusters, they used to be that an adjuster was like a very, prized, noble profession, kind of like a judge, right? Because you have to like really see what a case is worth. But now they have these computers, like all these like computer programs decide value, and adjusters could be like a kid who just graduated college who doesn't know anything, because it's more like just a data entry. Just enter the data with the computer, like the Colossus or whatever decides. So like think about what adjuster they're going to assign to your claim. If you're not even in court, they're going to assign like the lowest tier adjuster who probably only has authority up to like 20,000. He can't even give you more than that because he just doesn't have the authority, doesn't have the power, right? So like, what are you going to waste your time negotiating with him? I would just go for the lawsuit. Like, what do you lose? You don't really, what do you lose? $200 to file a lawsuit? Like, you get it back at the end. It's just, I don't know. But that's my opinion. I always say like file the lawsuit. Like, so yeah, but yeah, definitely. And make sure it's a real trial lawyer. They're willing to go all the way. And usually the big money is paid when you pick the jury or when you're in, when you're in court. And Hassan says, thank you for all you do. Come along with Uncle Joe says, good evening. How are you? Bearing it says, I was involved in a car accident. I was not at fault. I had 2 MRIs done for my neck and shoulder. The MRI for the neck showed that I have degenerative disc disease. Okay. Well, degenerative disc disease, you can't sue for that. That's what the defense argument, right? Degenerative means over time it degenerates or it gets worse. That's like the normal painless aging process. But you must have some, finding as well, because the idea is everybody has degenerative disc disease, right? If you're whatever age you are, let's say you're 48, so you have the spine of a 48-year-old. If you didn't, right? If you had the spine of a 6-month-old baby, that would be amazing. Wait a minute, it's a 48-year-old, but they have a spine of a 6-month-old baby. Whoa, how is this happening, right? So of course you have a spine of a 48-year-old or whatever age you are, but that's not the issue. The point is that before you had the crash, you didn't have any symptoms. You didn't have any pain. You were living your best life, pain-free, right? And now that you had the crash, guess what? The trauma on top of the degenerative, normal, painless aging process has now been, changed, because now you have the crash and the trauma, and it's affecting your normal, painless aging process, and all those degenerative changes are being like exacerbated. They're basically, you're waking them up, and now it's causing a whole spinal injury. You see, so that's the argument. So you can't sue for the degenerative stuff, but you could sue to the extent that whatever you had before was made worse. So it's really about that. So you need your doctors to comment on that. And then Jorge says, hey, Mr. Arkady, what percentage of cases settle after plaintiff's deposition when it's a rear-end case where the defendant is 100% responsible for the accident? Well, yeah, I mean, like, I think a lot of them will settle. I don't know, like, percentage. I don't, keep statistics on all the cases because, where, like in New York or in, like, there's so many cases, right, all over the country. But I would say, if you're not at fault, if it's rear end, you should make a summary judgment motion and you get a judgment. And then you could also get 9% interest on any later damages amount. So that makes sense for you to do. That could also be a driver to get them to pay money and to settle the case. But in terms of what percentage of cases settle, I mean, a case like that, most of them should settle. It just depends on what the injury is and how much insurance there is. Like if you have a case like that and you have, let's say, surgery and you have a small policy like 25, well, sure, they'll just tender the 25, or they'll probably even tender the 100. But if you have a case like that and then you have a rear end, and then you're saying, and then there's like, say 5 million in coverage, and you're saying you have a back surgery and you want all 5 million, they might say, well, we're not going to give you that. We'll give you something. We'll offer you like 300,000. So, you know, then you need to like fight a little bit more to show them, hey, no, wait a minute, my injuries are caused by this crash, and it is a serious injury, and then get them up and have them pay the maximum. Like we had that actually in a case just last week. We were working on a case for a very nice lady, and she had a head-on crash. She was just driving here into Brooklyn, and another car, you know, had to go over the double yellow line. It was like a head-on crash. And at first they were like lowballing her, 300,000. She had 2 surgeries. She had a fusion and she had another surgery. And then, you know, we finally had a trial date. And then finally, after, you know, multiple mediations, negotiations, they offered 2.5 million. And then I think she wants to accept it. I told her, let's go for more, because I always want to get more. I always want to do I thought we could get a little more. I thought we could get like 3, but she said, no, let's just take it. So we settled it. But, you know, see, that's how it works. You have to like really show them, hey, this is basically like, you know, this is a serious case. And if you don't pay this money now, then if we go to court, it's going to be a lot more. So, but yeah, I think from what you're saying, I think it should probably settle because you're not at fault. But it really, a lot of it would depend on how much insurance they have and also what the injuries are. Okay. And Sarah says, I'll text you again. Thank you. Oh, yeah, absolutely. I'll make sure to respond today. And then Alex says, so my car accident lawsuit was filed in June of 24 against 2 defendants. And now one of them filed a lawsuit against the other in the same case last month. Will this affect my own lawsuit in Brooklyn? 0% fault. No, it shouldn't affect you. If they're suing each other, that's not really anything to do with you because you're suing both of them, right? You have 2 different defendants. So, I mean, I don't know what they're suing each other. You're saying like, are they suing each other for like a cross claim, or do you mean like another person in one of the cars, like a passenger, is also suing like for injuries? Because that wouldn't affect you because that's, you know, that would be, he would be a plaintiff in his own case or her own case, so that wouldn't affect you. But either way, I don't think it really affects you, your case. And bearing it all says, the ortho said I have bulging disc C4 to C7, and the pain and discomfort I'm having in both my shoulder and neck are caused from a pinched nerve. I have attended PT. Right. So that's what you would probably sue for. You'd sue for that. That's a serious injury. That's, the fact that you have bulging disc from C4, C5, C6, C7, that's 4 different levels. And if those bulging discs are now pressing on the spinal canal, you know, indenting on the fecal sac, and then you're touching the nerves, because you have nerves going from your neck that go all the way to your shoulders, to your arms. And in fact, I think C7, T8, that goes to like the fingers here, the pinky. So there's dermatomes. You could look it up, get a dermatome map, and you can see where everything goes. But yeah, that's what I would argue. Yeah, not the degenerative disc disease. That's what the defendants want to say, but rather this, that could be a good case. Oh, and she says, I haven't reached out to a lawyer yet. I plan to. The insurance company is just trying to pay $2,500 for lost wages and pain and suffering. Oh yeah, don't fall for that. Like, yeah, that's what they always try to do. They call you up and they try to pay you like anywhere from $500 to $2,500, maybe even a little more, like $3,500, $5,000. But if you get a lawyer, you want to find out how much insurance they have, because if they have, let's say, $1 million, and then you end up needing, let's say, a percutaneous discectomy, right? That could be a $500,000 case. So why would you want to settle a $500,000 case with a lawyer for $2,500? Yeah, makes no sense. So they're just trying to do that. They want to like just pay a little bit and then get you to sign a release, because if you sign the release, well, guess what? Now you can't sue them anymore. So it's a great financial decision for them, but it's not good for you at all, because that's a big difference between $2,500 versus maybe $300,000 or $500,000. That's $500,000. And then Nico says, got hit by a commercial truck from the rear. I was completely still at a light. 2 rounds of injections, nerve blocks, and RFA. Recommended surgery down the road. What are you thinking? Yeah, I mean, like, I would find out like how much insurance the truck has. You know, I don't know where you are, but if you're stopped at a red light, definitely make a motion for summary judgment. Like in New York, if it's commercial private truck, you can get a judgment, and then once you have the summary judgment, now you have 9% interest. So, for example, like if you file the motion today, the judge in 2 weeks gives you the order. Okay, there's no issue of fact. You were stopped at a red light. The truck hit you in the rear. The truck is 100% at fault. That's your summary judgment. You have a judgment now on liability. But then, let's say in 2026 you have a trial and you win, $1 million. Well, now it's $1 million plus 9% interest, going back to, going all the way back to when this happened. So, to today, basically, to when 2 weeks from today, whenever the judge gives you the summary judgment. So that's how it works. So I think that's much better for you to do that. But that's a good case. Yeah, it's good. It should be worth a lot. I don't know where you are and all these things, but feel free to text me if you need a consultation. 347-566-9595. Yeah, absolutely. Absolutely. So let's see. Actually, I'll be back in 1 second. I apologize. I have to run like a quick errand. I think someone's at the door here. So I'll be back in 1 second. But yeah, I'm going to continue. Just hold on with me 1 second. I'll be right back. Oh, okay, I'm back. Sorry about that. Okay, so we were up to this question. We did Nico's question about being hit by the commercial truck from the rear. So yeah, that would just depend on, the amount of the policy, but I think that's probably worth, commercial trucks usually have at least $1 million. So with injections, nerve blocks, radio frequency ablation, it could be worth a few $100,000 at least, pain management can make it worth a pretty large amount, if it's built up the right way and everything. So, okay. And then let me see. Ash says, I have a case open. I was riding an e-bike and got hit by a car. 6 months later, I got into a different accident in the same case. Different people. What should I do? What will happen? So you have an accident. You were riding an e-bike and you got hit by a car. So that's one case. And then you're saying 6 months later, you got into a different accident. So it's not the same case. It's a different case, right? Different people, like you got hit by another car, like when you were driving your car or something else happened. So you just have to figure out what injuries are from what case. If you want to have both cases, open at the same time, you have to make it clear, because you don't want the defendants, right, the insurance companies in each case to then start pointing the finger at each other to say, look, oh, it's not from the e-bike, it's from that car crash. And they'll say, oh, it's not from us, we're just a little car crash. You already had all these injuries 6 months ago from this e-bike. So they'll just point the fingers at each other. So the best way to do it is if you can make it really clear, like, for example, I hurt my left hand in the e-bike case and I hurt my right leg in the case that's 6 months later. Well, those are two different body parts, right? Nothing to do with each other. Then you can have both at the same time. But otherwise, that could get a little muddy. It can get a little complicated, like a soup. So you have to be careful. But, if you want to pursue both of them, sometimes it doesn't make sense. You could also look into it and see, sometimes it's clear one was a serious crash where there was a lot of property damage and you're actually you feel pain. And the other one is more like a little, tap, nothing really happened. And of course you could go and sue and start treatment, but it's more like a orchestrated or feigned kind of thing. So maybe just drop that one if that's the case. But I would speak to your lawyer and just get their opinion as to how to handle that. But you could definitely do that. I mean, I've had clients who've done that. I've had clients who've had multiple cases. So that's something you could do. And then Burns says, we are trial ready and been asking State Farm for a court date so we can go to trial. They haven't responded back to us, and it's been a couple of months. What needs to be done in Miami-Dade? Oh, okay. So, usually, I don't know how it works in Florida, but I don't know why would you have to ask the insurance company for a trial date? The judge sets the trial date, right? As long as you file a lawsuit, and then the judge gives you the trial date. And then if they can't make the trial date that the judge gave, they have to then petition the judge for an adjournment, and the judge can say, okay, State Farm or whoever, you have another 2 weeks, and then that's your first adjournment. Maybe, okay, you really can't again, here's another month, but then now it's final, right? It's up to the judge. Well, why does State Farm get to pick the trial date? They're just the insurance company. if everybody let them pick, they could say, yes, I like the trial date of the year 2350. They'll never want to do the trial. Okay, and then Eric Wang says, currently in pre-litigation against Progressive, the initial offer is a lowball one, and my attorney made a counteroffer. However, Progressive didn't really budge much at all and is being cheap with the settlement. Is the next best move to file a lawsuit against their insured? Yeah, of course. You have to file a lawsuit. That's what I was saying before. You can't really, especially Progressive. Oh, Progressive is the worst. They're so cheap. It's almost funny. I stopped even speaking to them because I just get upset, because I speak to them and they make these stupid offers oh, I'll give you $13,000. I'll give you $6,700. What do you? It's not a property damage bill. $6,700 is what you would do to fix your car, for property damage. This is real life-changing serious injury. And they're just so cheap. So it's better to just file a lawsuit, because when you file a lawsuit, then you're in court and then you get to negotiate on your terms, go from a position of strength, show them I have these injuries, you have this much in coverage, pay me X. If you don't, that's fine. But then guess what? This opportunity to pay me X, whatever you value the case in, let's say you say, the case is worth $100,000. Pay me $100,000 by April 19th. But if you don't, that's fine. But then the $100,000 is going to be like the train that left the station, and you'll never have the chance to settle for $100,000 again. After April 19th, it'll be $250, or whatever your lawyer thinks. That's a much better way. You're in a power position as long as your lawyer isn't afraid to try the case. As long as the case is a real case that he can go to trial on, it's just better for you, because you can't really negotiate with them. They don't really come up, unfortunately. They're just really cheap. They have those ads, right? Like Flow or whatever. They're funny, but State Farm says you're in good hands. They have the quarterbacks, right? Like all that stuff. Jake from State Farm, all these companies. But in the end, they're just not, unfortunately, they're not fair. That's how they become billion-dollar companies, is by watching their bottom line and caring more about their own financial interests than protecting their policyholders or paying fair amounts to claimants. That's how they become, big, geckos or whatever, all these different things. So unfortunately, you can't really get much from them in a pre-suit usually. And then Zadie says, I had a motorcycle accident the past summer and I was a passenger. I have a mild concussion and whiplash. I'm still going to physical therapy and therapies. The driver's insurance is only $100,000. Is this worth to fight? Well, yeah, I mean, get as much as you can. If all they have is 100, if you have a concussion, if you've been treating for that, that could be a concussion is a type of brain injury. And then if you have also MRIs to show herniated discs or some kind of back injury plus a brain injury, you might be able to get the full 100 or close to it. So, yeah. And then T. Kizzy says, ADR next month, but I haven't had a real deposition. My lawyer said we were preparing for deposition last month, but only asked names of all my family in the county and if I have social media. Oh, yeah, well, that's not good. They should prepare you. But what do you mean by ADR? Is that like a mediation or an arbitration? I guess ADR could be any kind of alternative dispute resolution usually. So depending on which one. I don't usually like the arbitrations because if you get the wrong judge, they could just lowball you and then you can't appeal. It's just whatever they say is final. But mediations are okay because you come to the table, you try to settle, and if it doesn't settle well, you still have the opportunity to go to a jury trial. But with arbitrations, you don't. Whatever the judge says, that's final, and then you can't really even appeal, so they're kind of dangerous. And then Carve Life says, what is a reasonable amount of time to gather evidence and start forming a case in medical malpractice? We are about 10 months into records request and discovery. It depends on what kind of case it is. Like sometimes it takes a little bit of time, but something like that is usually probably the maximum time you'd want to spend, right? Because to get medical records usually takes a few weeks. You get them reviewed, maybe a few more weeks to get an expert to review it, as if the expert says, hey, I see the records. I think this is a case of medical malpractice. I see merit to this. Then you file a lawsuit and you start moving it. You don't want to sit on it too long. You only have 2 years and 6 months in New York, and other places might have different statute of limitations, but you don't want, there's no real reason to sit on the cases. And then Robin says, how long after you settle your case, how should you wait for my money? You mean how long after you settle your case you have to wait? Usually it's not long. If you settle, it's like 30 days, you get your money. The only time that it gets delayed is because, like, maybe if there are liens, especially like Medicaid, Medicare, that could delay getting the actual money to you. But the check should come to your lawyer within about 30 days or so if it's a settlement. And Willie says, thank you, sir. Oh, you're very welcome. Chris says, thanks for all your videos. Oh, you're very welcome as well. And go make it a little. Bigger here so I can see all the questions. And then Robin says, you are so great. Because of you, I could get a bigger settlement. I just settled my case thanks to you. Oh, thank you so much. I don't know what I did, but thank you. That's awesome. Yeah, I'm glad I'm helping people. That's what it's all about. It's all about helping serious injury victims and families. Like, I was really happy with this guy. He called me today. He goes, I settled my case with $1 million. And he goes, if it wasn't for, this lawyer that you found for me, the other lawyer, he never would have gotten, because he wasn't a trial lawyer, he had no trials, there's no way he would have gotten even more than 100, because like I said, even this lawyer, the one I got for him, at first they would say, there's no way we're going to pay more than 100. It was only after like really preparing for trial and showing them that, if they're not going to pay, they're going to go to trial. Then finally the insurance company said, okay. And they coughed up some real money. But I'm happy I was able to help Robin as well. And Lakeisha says she just texted me. Okay, great. I'll definitely respond. And Daddy Boy says, what happens after a lawsuit is filed? Lawyers pay jury fee and before case management conference. We already paid the jury fee and case management conference is scheduled. Okay, yeah. So usually what happens when you file a lawsuit, you give the other side time to also appear in the lawsuit, and that appearance is usually called an answer, because you file the lawsuit, the summons and complaint, and then they answer the lawsuits. They appear and they basically answer. Usually they just deny whatever you say. If you say they were negligent, they say we deny that. That's usually, it's just an answer. And then you go to the judge, and the judge will do a preliminary conference. So it's like a scheduling order. The judge will say, you give them documents within 30 days. They give you documents within 30 days or 60 days. Then, plaintiff's deposition, you have to testify, and they're going to ask you questions like, what happened? What are your injuries? What can't you do that you were able to do before? You answer their questions. Then your lawyer asks questions of the defendant, depending on the type of case it is, car crash, you got to prove liability, that the defendant was at fault, things like that. So, and then once all that is done, then you get a trial date. But depending on where you are, it's going to be different a little bit. Like in New York, we first certify as trial ready by filing what's known as a note of issue. And you could only do that when all discovery is complete, both document discovery as well as all depositions. And then from that date, from the note of issue date, when you certify as trial ready, you have to wait another year or maybe sometimes more than that, and then you get the trial date. But in other places, there may be you get the trial date right away, right when they file the lawsuit, and they're being told, okay, you filed a lawsuit today, you paid this jury fee, now you have the trial 14 months from that date, from when you filed. New York, it's not like that. So every place is going to be a little different. And then Sean says, Arkady, thanks for your referral in Iowa. They are doing way more than what my other attorneys had even mentioned to me. Very thankful. Oh, that's great. Okay, yeah, that was another person I helped. Yeah, in Iowa. Yeah, that's great. That's great. Yeah, I know excellent lawyers in Iowa, so I was glad that they're able to help. Yeah, those guys are really good. Yeah, actually, I think that's part of the same firm where I don't know if you guys heard about it, but last week there was a verdict, I think out in California, on a Starbucks case where a guy got burned. Actually, I did a little video about it. I'll probably have to do another video. I didn't watch the entire trial, but there was a Starbucks. I think it's called I forget what it's called, but it's basically like a tea, and they were making this really hot tea, and so they put the cups in the holder. And they put one cup not all the way down, so one cup got pushed down, the second cup got pushed down, but the third cup wasn't really pushed down all the way. And then she gives it to the guy in the car, and he's wearing shorts. And the cup that she doesn't push down flips over. It's really hot. It's like boiling tea, and it burns him on his genital region. So he had really bad burns. He couldn't have, instead of enjoying something like intimacy, now it's painful for him. He had burns. He had all these injuries, post-traumatic stress disorder. But anyway, the lawyer tried the case, and I think he got a verdict of $50 million. 50. So that's really good for really amazing verdict. So I'll do a video about that case, and I think that's the same firm that they have an office in Iowa. But yeah, that was really amazing verdict. I think in California it was 12 jurors. They needed to get 9 out of 12. So 9 out of 12 agreed to the 50. But the lawyer in the closing argument said that they should allow for a range between 75 and I believe it was 75 million to 125 million. So then the 3 jurors that didn't agree, you would think that those jurors maybe didn't want to give anything or didn't think the case was worth. No, those 3 jurors that were the holdouts, that didn't agree with the 9, they were actually, all 3 of them were crying, and all 3 of them wanted to give 125 million. So that's a really good lawyer. I mean, if you can get that much money. I watched some of the trial. I didn't watch all of it, but I'll go back and do some videos about it. I thought it was interesting. But I think that's the same firm as what Sean. So you're in good hands. If they can get 50 million, in that case, then you're in good hands with those guys. And then Moha says, hello, Arkady. If I take a workers' comp settlement on a denied claim, would it affect my third-party case, knowing that they are not going to accept the injuries but instead settle on them? So if you take a workers' comp settlement on a denied claim, would it affect the third-party case? I mean, I would definitely ask your lawyer about that. I'm not sure. I don't want to tell you the wrong thing, but I don't think so because, first of all, a settlement is usually confidential. So if you settle the workers' comp, I mean, the way they do it in New York is like you have workers' comp is just like they pay you for your lost wages, and then they pay doctors to give you medical care, right? So those are two types of payments that you get. You get money for your lost wages because obviously you got a work accident, you can't work. You get lost wages, your paycheck losses, and then the doctors get paid for giving you medical care or treatment. So that's money that goes to other people, but it's because of the work accident, right? So you're entitled to those two benefits. Now, sometimes you get those smaller checks and you get a check once every 2 weeks, whatever it is, $1,000 or whatever they, maybe a little more, but whatever they pay. Now, in New York, they have this thing called a Section 32 settlement. So instead of getting those smaller checks every 2 weeks, you get one big check, like a lump sum. It could be $50K, depending on how bad the injury is. It could be $100K, right? And now you have that check. And then basically they get a credit. So they stop paying you the smaller checks, but they still kind of count as if they're paying you the smaller checks. And then once it gets exhausted, let's say you're getting $1,000 every 2 weeks. So once that gets exhausted, once the $50K or whatever gets exhausted by the smaller check, then you can apply again and start getting the smaller checks again. I think that's how it works in New York. I'm not too sure because I don't really do workers' comp. I usually have a workers' comp lawyer handle that. I just do the third-party lawsuit. But I don't think it would really affect your third-party case. I don't think it would affect it because if the workers' comp case was somehow denied, but then they paid you a settlement, that's already kind of, acknowledging that it's a valid case. Because why would they pay you money if it's a denied claim, if it's not a valid case, right? So I don't think it really would affect you, but I would definitely check with your lawyer about that. And then the machine says, hi, Arkady, I'm scheduled for surgery next month and my trial is in May. You did a verdict search on him and his last trial was back in the 1990s. I don't find this guy aggressive enough for my case. Well, yeah, I mean, it just depends on what you want to do. If you're having surgery, then definitely, get that done first. Don't worry about the trial being in May, because remember, if you're having a surgery, they might want to have a post-surgery deposition. So the trial might not be in May, it might be in July or, June or whatever. Don't really worry about that. The lawyers will figure that out. But if you feel like the lawyer is not aggressive enough, then, you have to really sit down with them and make a decision. I can't really tell you what to do, but it's up to you, really. You're the client. So, it's up to you. If you feel like you want him to do it, let him do it. If you feel like someone else could do a better job, you could always possibly switch. Although, like I was saying before, sometimes it's hard to switch very late because then the new lawyer, unfortunately, doesn't really get very much in terms of payment because the first lawyer already did all the work. And plus, the first lawyer already did everything in a certain way. So then if the new lawyer doesn't like something, they can't really change it. It's kind of like if somebody's cooking a dish, right? And they're almost done. Like they baked the cake and they just have to put the cherry on top. Do you really need someone else to come put the cherry on top? Doesn't matter. They already baked the cake. You can't really unbake a cake, So it's kind of like, I don't know. It's hard to say, but I think probably if, probably they'll be able to settle it for you, especially if you're having another surgery. So, but yeah, feel free to reach out to me. I'm happy to help in any way I can. And Danny Boy says, I hurt my knee in my accident and my doctor gave me some exercises to do to regain strength in that knee. Do I need to push the doctor for an MRI before we go to court? Yeah, I would probably do an MRI. You're saying you hurt your knee and it was in an accident, like a car crash, but the doctor just gave you exercises and there's no diagnosis of an injury of what the injury is to the knee. If you don't have that, it's going to be hard to get much money in court because, the orthopedist, if he's an orthopedist, he can come and testify, okay, I see some kind of whatever, subluxation in the knee, whatever the diagnosis is. But like, you know, if you don't even have an MRI is usually like, that's the diagnosis. It's a torn meniscus, it needs surgery, right, or whatever it is. But if he's not even recommending an MRI, then he doesn't even know what the injury is. So then it becomes like a contusion or like a boo-boo, that it's not really worth much. So I would ask him for that. Why not? It doesn't hurt. And then Corey says, I've been so distant, just been so confused and not knowing what is the right move to make. Go under the knife again for an ACDF cervical surgery. Oh, I see, right. Whether you want to do that or not. Yeah, I mean, you have to make, that's a hard decision. You kind of have to make that kind of decision together with your doctor and see if it makes sense. Because yeah, that is an anterior cervical discectomy infusion. They remove the disc, they put in an artificial disc. It's a serious surgery. You know, it could be life-changing in the sense that when you do one level, then, you know, in 10 years, you might need the level above, and the level below also could be medically needed for another fusion, and you lose mobility, right? Because they're fusing your neck there, and then you can't bend anymore. You can't have that mobility. So it's a serious injury. And Alex says the defendant that's suing the other is suing for his own personal injury and damages, but they are both at fault for causing my personal injury. Oh, I see, right. So then it doesn't matter. You know, the fact that they're suing for their own as a plaintiff doesn't really affect you, because you're suing them, you know, they're defendants in your case. So as long as the insurance is there, you still have the insurance. So it doesn't matter. Sometimes they sue, sometimes they don't sue. That doesn't really matter. And then Eric says, thank you. Oh, you're very welcome. Yeah. And Zadie says, thank you. And Nanette says, hello, you rock, 100. Oh, thank you. And RG Society says, I'm 1 week away from mediation and trial is in 3 weeks. The defense has not sent any proposal for settlement, and my attorney told me that's positive. Do you know why? I mean, it's hard to say why. I mean, unless, you mean the defendant has not sent any offer? But I mean, has your lawyer made a demand? Has your lawyer said, I want, like, for example, $1 million, and then he's saying against my demand for $1 million, the defense attorney is not giving any number, like there's no offer? Because the defense usually doesn't do a proposal for settlement. They usually give you an offer, but first they want you to make a demand. So, you know, that's usually how it's done, most people. But like, you know, you could also do it the way I was saying, like where you write them a letter and you say, here's all the evidence and I want like $1 million. And if you don't pay it, then it's going to be 2. But that's more of a new thing that I'm, you know, doing, and some other lawyers do it. I kind of, you know, learned it, but most lawyers don't do that. So that's kind of more of a settlement opportunity type of way of doing it. But I don't know why that would be positive unless the lawyer wants to take a verdict and thinks that he can get more in court. Because he thinks any offer might be small. But usually an offer that's reasonable is good because it's like a guaranteed, right? Like say, I'm saying, hey, I think this case is worth $1 million, and they call me back and they say, no, I don't think so, but I have 850 for you. Well, I could call my client and say, well, okay, we're pretty close. Maybe I can get you 900. We can settle it, because that's guaranteed money. And, you know, it's like a contract, right? You sign the paperwork, you get the 900,000 or whatever you agreed on. So I don't know why an offer would be bad, but like if you go to trial, you could get $1 million from the jury. Then they'll say, you know what, we're going to appeal, and then the appeal could take 2 years, and then the appellate court could say, you know what, yeah, $1 million is not what's reasonable for this kind of injury. So do another trial, or take like 200,000 or whatever. You know, it's just, so a verdict even is not guaranteed to get the money, but a settlement is. So a settlement is usually good. And then Carve Life says, can we text you a question? Yeah, sure. Just text me 347-566-9595. I'm happy to do a call as well, and we could speak with you. I usually just, you know, when you text me, I just ask, give me like the brief facts, just 1 or 2 sentences as to what happened, the injury information, if you know it, your city, your name. You don't have to give me your full name, like your first name, John, or whatever, just so I know like who this is, like what city you're in, what happened, like 1 or 2 sentences, just so I could kind of almost like see it happening, but very brief. You don't have to put, some people start writing these, you know, I can't really always read like long, you know, War and Peace, like treatises, just like, you know, just 1 or 2 sentences, and then injuries. And that's really all I need. And then we could schedule a call, and we could discuss everything in more depth on the call. Okay, and then Jordy says, do you try to settle with Uber or do you go straight for the lawsuit? With Uber, it depends on the type of case, but I think usually I try to file the lawsuit because Uber, usually I try to file the lawsuit unless there's something like with Uber. The only issue with Uber is like sometimes they have that clause where people use the app and then people say, well, they're arguing that because you use the app, you agree to arbitration. So then they try to take you out of court. And different judges will rule differently on that. Sometimes judges will agree and say, oh, yeah, because you clicked on that app, that you agreed to their terms and you can't go get a jury trial. So they're basically taking away your right, your Seventh Amendment right in the Bill of Rights to a jury, which is terrible. But so sometimes you have to do arbitration with them. That's the only real terrible thing. But hopefully that kind of the courts kind of weigh in on that and fix that for the plaintiffs. And he says, are car accidents with Uber passengers easier because we weren't driving? Yeah, of course. Passengers are always good because passengers are not at fault. So, yeah, absolutely. And then Chris says, I just got a trial date for October of next year. Is that good? Yeah, I mean, that's not bad. You mean October of 26 of next year? Oh, yeah, I mean, at least you know when the trial is. Yeah. And Charles says, what happens when a lawsuit is filed in one county, but the defense attorney are from another county? Does voir dire and the venue proceeds to the county of the suit, or is there a neutral county? Well, usually it's going to be like where the lawsuit is filed. So that's where the case is. So, for example, if you're in, let's say, Kings County, which is Brooklyn, where I am today, right? If that's where you file the case, it doesn't matter where the law firm could be from Manhattan, Bronx. The law firm could even be from New Jersey, a different state. It's going to be a Brooklyn case because it's filed in Brooklyn. So yeah, the voir dire is in Brooklyn. So it's the same. Yeah, it's wherever it's filed. And then Low Vault says, when a settlement isn't reached in mediation, does the defense usually hold off on further offers until near the trial date? I mean, they could. If they didn't settle it at mediation, it just depends on what happens post-mediation. Like if it was close and then you say, hey, I just need a little more, let's talk, or if it's really far apart, then you might say, look, whatever you offered at mediation is ridiculous, so we're going to trial, and then at trial, when you pick a jury, they might have a new number for you. So it just depends on like how far apart you are in the numbers and how long after the mediation is the trial. But if the trial is coming up, it could be that they're going to pay. Usually they do pay during the trial. And a critic says, how much do you think a discectomy surgery costs to the neck and back rear-ended by a big truck in New York? Yeah, so I mean, if you got rear-ended by a big truck, as long as the truck has enough insurance, like if it's $1 million, sometimes it's more, it's like $1 million with like $5 million excess. If you have a discectomy surgery, if it's a full-blown discectomy to the neck and to the back, so that's two different surgeries, that could be like 1.5, 2 million. It could be a pretty big case. And then Alex says, thank you, Mr. Frekhtman. Are you very welcome? And I said, and also 4 epidurals. Yeah, I mean, the 4 epidurals probably won't make it that much more, but it's probably something like that. It could be over $1 million easily. If it's real, like full-blown discectomy, it could be 1.5, 2 million, maybe even a little more than that. And then T93 says, does it matter if your building switched management companies while you have a personal injury case with the old management? No, it doesn't matter because it's like whoever the insurance company insured, right? The policyholder, whoever it was when you got hurt back then, that's who you're suing. So if they switched afterwards, it doesn't matter. And how about this? How is Liberty Mutual when it comes to settlement and courts? Liberty Mutual, I mean, they're okay. I've had cases with them. Sometimes they're a little cheap, but they usually pay. You just have to kind of, force them to pay. And Short Guy says, how is USAA when it comes to settlement in court? Yeah, USAA, from what I've seen, like they're a little cheap too. Like I have a case now with them where they're a little bit cheap. I wrote them my 30-day letter, but they said they need a little bit more time, like 2 more weeks. Let's see. I'm going to see what they I mean, they put some money on the case, but they didn't really put a huge amount. Like it was like a arthroscopic type case. So they put like 100, 120. I was trying to get more. Let's see how much more they put on it. But yeah, I mean, I wouldn't say they're not like going to throw money at you. They tend to be cheap, but you could make them pay if you have a trial lawyer who's willing to go to court. And Jay says, if you were a passenger in an Uber with 2 herniations, what happens? How long does this process work? I'm in pain. So if you're a passenger in an Uber and you have 2 herniations, so you have to file a lawsuit, maybe against the Uber, but also against the other vehicle, right? Depending on how the crash happened. It could be the Uber driver was at fault, it could be the other car was at fault, it could be 50-50. So you just file a lawsuit. As a passenger, you sue everybody who was involved. So you have coverage from all of it. And you just go through the process, and then you could try to settle it, or if they're not settling, you just have to go through the process and get a trial date. And then Mr. Rahman says, I have one question. I spoke to my paralegal, Ray Robinson. He told me that if I don't get a surgery for my herniated disc, my case will only be worth 20 to 25K, but I'm not comfortable to get a... Oh, yeah. Well, I mean, just text me. I'm happy to speak with you about that. Just text me. Let me know. It's up to you. I mean, like, basically, whether or not to do a surgery is really a decision you have to make. You have to make that decision with your doctor. The lawyer could maybe give you valuations, like ideas. Okay, if you get, and the only thing they're really telling you is what they've seen in other cases, in past cases. So they could say, okay, in past cases, I've seen people get surgery, they get like 500,000. People who don't have surgery, they get like 25 or whatever it is, right? Doesn't mean you're going to get that. You could get more, you could get less. They're just giving you like estimates of what they've seen in their experience. But yeah, I'm happy to speak to you about that. But that's really a decision, like I said, you have to make with your doctor, or with yourself, right? If you don't want to do it, don't do it. It's really up to you. And then Nico says, how is Travelers with their cases? Do they tend to settle? Yeah, Travelers, I think, is pretty good. I mean, they're all like fine. It doesn't really matter. It's not like one is really great, like Travelers gives me millions, right? And then the other one, like Liberty Mutual, says, no, I'll never. It's just like they're all like the same pretty much. I mean, honestly, like some of them are a little better. Like American Transit, the one that insures the yellow cabs, they were terrible. They wouldn't pay anything. They don't respond to anything. They're just like, but it's not like one company is like paying money, right? It's not like a slot machine where you hit State Farm, ding, 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 and then you get like the 3, whatever, you win, and it's like a slot machine and money comes out. And then you get, Liberty Mutual, they're like, you get like the Apple and the Cross or whatever, you don't get any money. It's not like that. It's just that they're all insurance companies. They have, it depends on how much policies they have. It depends on who they hire to defend the case. Sometimes the same carrier, if they hire one firm, that firm is just like more annoying, right? And they might defend really harshly. But then in another case, they might hire a different firm, and that firm is easier, and then you get more money. So there's a lot of different variables, but it's the same company. It's just hiring 2 different law firms. It could be the law firm. It's a lot of different things, but so yeah, it's hard. It's hard for me to say, but yeah, definitely. I mean, definitely some carriers have better reputations. Like Travelers is good. Like USAA is a little cheap. Allstate sometimes is cheap, but you could make them pay. Like I settled a case with Allstate where they paid me $1 million. It was a lady who got hit by a car, but she had a brain injury. At first, they were like, I sent them a letter. I said, pay me the $1 million. And they were like, they didn't even understand. They were like, what if it gets better? It was like blood on the brain, subdural hematoma. She was like, really injured. Like she was putting on the stove, watching her grandkids. She would forget that the stove was on. The parents couldn't let her stay home with her grandkids. She had a real serious brain injury. And they said, what if it just goes away? Like, what? Like, it doesn't just go away. Like, it's medically impossible. It's like nonsense. So I could see these adjusters don't even know what they're talking about. So then because of my letter, I just stayed, tough with them. They changed law firms. They put in a new law firm. They reviewed everything. And then they ended up just tendering the full $1 million, even though it was Allstate. And they're like supposedly like one of the worst, right? So you just have to, it's really about the case. Make the case as strong as possible. The damages, the human story, the liability, hire the right experts. It's not really that much about who the company is. Although that does play some role, but it's not the big ticket item. And the machine Marte. Oh no, there's another comment. Remember me without saying much, but we spoke on the phone. Been trying to decide if to stay with my current lawyer or change over, but I've been confused. I'm not sure what to do this entire. Oh, okay. Yeah. Just text me. I'm happy to chat with you. I mean, it doesn't matter if you decide to switch or decide to stay. Whatever you want to do. It's I don't. I'm happy to help either way. Yeah, but feel free to text me. I don't know exactly who it is from the I don't remember all the usernames. I'm not that good. I don't know. It says Dip Vivo. I don't know all the usernames, all the YouTube names with the real names. But yeah, just text me. I'm sure I have you. Usually, if you texted me before, I probably save a little note about what the case is about and your name and my phone, so I probably have it there. And a critic says it's not a full-blown discectomy. Oh, okay. So that might be a little less, but still, I've gotten 548 on one perk disc. So if you had two, I think that's the one you get cervical and lumbar. It could be, 750 to $1 million. And then the machine Marte says, what about State Farm? Did they pay? Yeah, State Farm, they pay. I just settled the case with them. They paid the full policy limits. Yeah, State Farm pays. Sometimes they don't pay right away. You have to make them pay. And RDOT says, thanks for the consultation earlier today. I truly appreciate it. Oh, yeah, absolutely. Thank you for reaching out. Yeah, sorry I couldn't get to you earlier. But yeah, and feel free to reach out. If you have issues, I'm happy to speak to you again and help in any way I can. And then Jay says, what happens if my attorney is not telling me how much the policy is? Always, I'll call you later. Sounds so doubtful. Don't want to pressure anyone, but I don't want to do surgery if I feel I'm not covered. No, of course. Well, the attorney should tell you how much the policy is. If they're not telling you, just, maybe email them or ask them or, they have to tell you. Why wouldn't they tell you? It's not hard to find out. Once you file the lawsuit, it's part of in New York, it's automatic, right? It's part of the CPLR, the Civil Practice Law and Rules. It's under Section 3101. It's in the insurance law, 3420F, even as a claim before you file a lawsuit. And there's another section, I forget what it is, the 3122 or something, where there's 3 different rules, and they have to tell you the full primary, any excess, any umbrella, any supplemental, any concurrent, basically any policy that covers your incident. So they might have a primary. The primary could be for example, $250, but then they could have excess, umbrella, concurrent, supplemental, and that could be another $1 million. It could be another $3 million. It could be another $5 million, right? So just ask them. They have to tell you. And if they say, we're not aware of any, that's not a proper response. Then you have to do an affidavit of search. You might need a broker affidavit. Whoever's the broker that procured or obtained all these policies, they have to sign an affidavit. You have to know for sure, what the policies are. You want to know that. And then Sandy says, evening Arkady, excited for the news next week. Oh yeah, okay, yeah, absolutely. I'm following up with them to see. We're trying to settle a case for Sandy, so hopefully we get that settled. And Short Guy says, it states online that when a car accident injury goes to trial, it turns out being 50 or 60% chance to win the trial. Why is the percentage very low when PI cases head toward trial? So it states online. I don't know. I mean, every case is going to be different. You mean a car accident, so you're saying that it says that only 50 or 60% chance that you're going to win any car accident? I don't know. I've never heard that before. I think it depends on the case, right? If you are stopped at a red light and somebody rear ends you, 100% you're going to win, right? But if I don't know, you change lanes and someone else changed lanes at the same time, well, now it's 50-50, right? Because you both did something. So they can say you're at fault. You could say, no, they're at fault. So I think it just depends on the case, but yeah. And then Jordy says, can you tell me what you would ballpark a shoulder surgery with anchors? Yeah, I mean, shoulder surgery, I had one with anchors that I did. I think we got I think we had one for $650 and maybe another one for $850. With anchors, it could be pretty significant. It could be even over $1 million because the anchors are pretty serious. But the one I'm thinking of, I think, was a premises case, but it was a strong liability where they had this rubber on the step and the whole rubber came off the step and he fell, but it was he had complained about it before. So it was a pretty strong liability. So liability plays a role too, meaning can you prove that they were at fault? And then Felipe says, hey, I want to set up a consultation face-to-face. I just texted you. Yeah, sure. I could do maybe a call first, then we could do a Zoom, or if you want to come in, you can come into the office, depending on what it is, if I can help you. And Short Guy says, yes. Okay, yeah. So yeah, that one, I'm not sure. Like what they say online depends where you read it, or, I don't even know if that's accurate, but, And then Kevin says, once a case is in the docket, what is the chance that it will settle before trial, such as settlement opportunity mediation? I mean, I think most cases do settle, like 95%. Usually the only reason it doesn't settle is because the numbers are just far apart. Like if somebody's looking for like, $1 million or something, and then the other people are like, look, this just isn't that kind of case. I'm only going to offer like, 50,000. Well, they're so far apart, you have to go to trial. But usually most cases do settle. And Sandy says, if a personal injury lawyer gets into an accident and hurt, can they represent themselves, or they have to hire another lawyer? I mean, they could represent themselves, or they could hire a lawyer. Probably it's better to hire a lawyer because you have somebody handling it for you, because if you're representing yourself, it's kind of weird. It's like you'd have to be the witness and testify, but then you'd also have to like object or be a lawyer. So it's like two different roles. But you could, I mean, you could represent yourself, I guess. And Charles says, I'm in the early stages of a nursing home lawsuit, and the defense attorneys are from your area. If I texted you and mentioned their names, would you have any idea if you worked against them? Yeah, sure. If I know them, I could give you my input as to what kind of lawyers they are, and whether they're good, or give you my feedback. Absolutely. And Felipe says, we spoke before. I got sideswiped by a truck in Manhattan with a $4 million policy. Oh, okay. Yeah. If we spoke before, just text me again. I'm happy to chat, and we could meet as well. Yeah. Because like I said, if I spoke to you before, I keep your name and I keep a little summary of what we talked about usually. So I could, I'll probably get you might have to refresh my memory quickly, but we'll get back on track quickly. And Kevin says, I'm a CPA, but want to get a law degree and become a tax attorney. Do you have any advice on law school? Oh, yeah, that's a good idea. If you're a CPA, but you can go to get a law degree, and then you can become exactly a tax attorney. In terms of like, you mean advice like which law school to go to? I mean, there's a bunch of, depending on where you live and what you, but it doesn't, I don't think it matters that much. I mean, some law schools might have, be really good for like tax, off the top of my head, I don't know if I know, but I think maybe like, was it NYU that's really known for tax? Or I know some law schools are known for like tax law. So if you want to go to one of those, I don't know if it's NYU or one of the other ones, but some of them are known for that, like the LLM, for example, or a degree in like tax specifically. But there are a lot of good law schools. I went to the University of Texas at Austin. So I was at UT Austin for law school. I liked it there. There's a lot of great law schools in New York and the East Coast. Obviously, there's like, of course, Harvard, Yale, and all the famous ones. But then some people go to like smaller law schools that you never even heard. Actually, this lawyer that won the $50 million case on Friday, he went to a law school like that's a smaller law school you probably never even heard of in California. He's doing great. He just had a $50 million verdict. So it doesn't really matter what law school, as long as you're comfortable there and you like it. And then Nico says there was a way to research a lawyer's past settlements to see if they're a trial lawyer or not. Yeah. I mean, you could do a verdict search. I've been doing that for people, and they text me. I've been doing verdict searches, and I can email you back the results. I just have to renew because I think my verdict search is about to be renewed, so I have to call them to just renew it to keep it going. But I have other ones, like one of them has to be renewed, like verdict search. But I have the Westlaw one and some other ones that are active. So, but yeah, I can do the search. And then Short Guy says, MRI shows I have plenty of 1.5 to 2 millimeter bulging disc throughout my neck and back, and the doctor recommends a C6, C7 surgery that I won't pursue. I've done plenty of injections. How much do you think the cases like this would settle for? So bulging discs, and he recommends surgery, but you're not going to have the surgery. Well, I mean, depending on what kind of surgery, if he's recommending like a full bone fusion, you could say, well, the doctor thinks I medically need a fusion and I have this painful, bulging or herniated disc. So then it depends on how much insurance they have. But If they have, let's say, $1 million, you could make an argument, hey, look, I'm going to need to get the fusion. Maybe I'm not going to do it now because I'm afraid, but eventually, like in 10 years, I'm going to have to do it because the doctor says it's medically necessary now. So I'm going against medical advice now by not doing it. But what about in 10 years? What about in 15 years? I don't know, how old you are. But that could be worth a lot. That could be worth a few $100,000, or even if it's prepared the right way, even, if they believe that you're going to need the surgery. Because just the surgery, if it's a fusion, is like $100,000 surgery. And plus all the pain and suffering with that, it could be into the millions. So, it's hard for me to say, I don't know where you are, what city, I would need to do a full consultation to give you estimates, but it could definitely have substantial value. Okay, everyone, I have to run, but thank you so much. This was good. We did a lot of questions, and we'll do another one maybe later this week or definitely next week, and I'm going to do a few more videos as well. Let me know if you have any questions. You could ask us if you want a video about a certain topic. Just let me know. Just you can text me privately or put it in the channel. And if you need a consultation, just text me. It's 347-566-9595. I'll drop it in the chat as well. We are here for you. Our goal is helping serious injury victims and their families. All the best to you, and we'll talk to you very soon. Have a great night.